session of the second day of our conference. We will have Professor Susi giving his paper. Then we will have two commentators. I will give first the floor to Professor Brest, a guest from Slovakia, I understand. And then to Professor Monticelli, professor in-house. And after we could open a discussion. I think I've seen that there are already, I have the sense that there are a few questions that would be like to be raised. I think we'll do first, without further ado, the floor to Professor Susi.
So good morning. I guess my presentation may be the least philosophical one, but perhaps the most entertaining. And if you live with me through the presentation, you will know what I mean. Because there is not too much philosophical about internet. We could even say that there is not too much legal about internet. But that by itself may be a philosophical question. So, what do we know about internet and human rights law? Can you say that there is such a phenomenon as the right to internet? Perhaps there is a new human right to internet. Or is there overall a right to internet? I will start with these questions, and at the end I will try to answer to that question through looking what happens to conflicting rights in internet. But to try to explore first the question whether there is a right to internet, we can apply the methodology of recognition, novelty, and rhetoric. The usual methodology we can apply when we analyze some new rights. As for the recognition, we can ask whether internet is just a new tool of communication or whether it is indeed a separate right. What is recognized, and it is recognized on a consensual basis, is that there is a new legal reality when we enter internet. Namely, there is a triadic relationship. You have the alleged victims, you have the intermediaries, and then you have the internet users. In traditional relationships, there would be no intermediaries. Intermediaries, of course, are these internet companies, online news portals, where the violations may happen. And it is also recognized that these traditional conflicts of fundamental rights, predominantly, of course, freedom of expression against the right to privacy, remain and prevail in internet. So a question could be, I'm not sure if it's a philosophical question or a more pragmatic question, how can balancing of different rights operate in a triadic relationship? There is the second methodological question is that of the novelty. Whether we can say that internet is a new right. The International Covenant on Civil and Political Rights, you probably are familiar with that. There is quite an extensive academic debate whether this Article 19.2 already protects the right to internet, because there is reference to media of one's choice. But perhaps it is not even so relevant for today's discussion, And then there is my good colleague Dina Shelton, who in reference to human rights has said that all new rights are old, but I guess she may be mistaken in this context. And third is the matter of rhetoric. And here we see that there is exceptionally powerful rhetoric when academicians write about internet. Some people say that legal regulation ends when you enter internet. Some people say that, which is of course true, that information disseminated in internet can remain persistently available online. It creates a challenge. You no longer can erase that. So the question now is the method of balancing of conflicting rights applicable in internet? Now, do excuse my naivety in the following presentation. A few slides, I have departed from the understanding you should be able to explain law simply as you would be able to explain to your grandmother. So the way how I understand it, it's the traditional balancing scales which courts apply. You have the court and you have the expression, freedom of expression, and then privacy. And you deal with a public figure and the freedom of expression is more weighty. And then you add an element that this public figure has a child and it is balanced out. And then suddenly it emerges that the politician maybe has a health issue and now it is more weighty is the privacy, but then it comes out that this health issue of the politician is connected to public health policy, so it is evening out. That is the traditional way. But now what happens when we move to internet, suddenly it changes. You no longer have the scales, you have a seesaw, as you would say in English. You have a horizontal relationship. You can put Google, Twitter, Facebook, whatever medium there, and you have on one side privacy and the other side expression. And I believe that I will demonstrate a bit further that the starting point in a horizontal relationship is not horizontal, but it is towards the freedom of expression if you give the right to intermediaries to start balancing. So what further happens, you add hate speech, you add threat to public security, you add child pornography, and then it only gets more weighty and you can limit the freedom of expression. Now, what are some of the main problem areas if we speak about the conflict of fundamental rights in internet? I will just name them because there is a lot of discussion can be about any of them. The first would be the intermediary liability. A lot of court cases, a lot of articles about that. The second would be personal data control. To what extent you can do that. The third, which is quite important, is that we see the change of the traditional meaning of the journalist. We see the emergence of this citizen journalist. We all can be journalists in some sense, and then we can ask the question, in a horizontal relationship, to what extent the citizen journalist can be held accountable. Of course, we have constitutional level problem solving because European constitutional courts as well as national constitutional courts are solving these problems. But now we see what is more important, that EU legislation is based on this concept of horizontal response, namely the concept of this safe harbor, saying that if you have a horizontal relationship and you have the internet intermediary in between, the internet intermediary should not be held liable. And that is very clearly written into the EU Commerce Directive. Of course, in the United States, there seems to be more absoluteness given to the concept of safe harbor than in Europe. And speaking more about the problem areas, there is always this issue of the technical possibility to control internet. It is said that internet is always one step ahead. So a semi-conclusion could be here. Perhaps there are valid concerns about the ability of the safe harbor concept to secure adequate response in resolving fundamental rights conflicts. The next topic would be the question of standards. Do we assume, or perhaps it is recognized, that in internet context, the standards which are to be used in balancing conflicting interests, whether they are the same or whether they are different? And I must say, when I was preparing this presentation, one of my biggest surprises was that they are supposed to be the same. We had here in Tallinn University on Monday, Michael O'Flaherty, who is currently the General Director of Fundamental Rights Agency of the European Union. But before assuming that position, he was the member of the United Nations Human Rights Committee. Those who know the documents of the Human Rights Committee know that there is this comment number 34 to Article 19 of the International Covenant on Civil and Political Rights. Into that commentary is written expressly that the standards applicable in internet when balancing conflicting rights are to be the same as in other situations. And it was quite interesting to hear Mr. O'Flaherty repeating the same proposition, because we as lawyers know we sometimes use the term the will of the lawmaker or the will of the lawgiver. Very clearly we heard from the primary source what was the will of the lawgiver when writing this commentary. So there is one argument saying that the standards are to be the same. We ask the question, why? I'm not sure if there is at the moment a valid response. Why are the same? But O'Flaherty is not the single one. We also see from other sources that standards are to be the same. You take the Google judgment. We all know what it is. There is the standard about public interest. Public interest needs to prevail. It is the same standard which is being used in other court judgments. And now a very long quote, no need to read it all, but just when in the Delphi judgment, the Court of Human Rights says both the right to freedom of expression and the right to privacy deserve equal protection. Again, I'm reading it, I'm asking why. There is no good explanation, but the narrative is that the standards are to be the same. Now, several American judges, I've read quite a lot of articles by them, say we are confronted often with the need to balance different interests in internet. We are told that we should develop new standards, but we have no time. At the end of the day, we do what we know to do best, we balance. But at the same time, there is certain emerging scholarly consensus that the freedom of expression may be overemphasized at the stake of privacy. So one question would be, is it a matter of degree versus, or is it a matter of fundamentally different standards? Now, I remind you, we still are exploring the question of balancing fundamental rights in internet. So is there any position of the international courts and the legislation? And here, surprisingly, we see very clear positions. We see the position of the Strasbourg Court, where it says that the balancing which is done by internet intermediaries, online media companies, is an appropriate tool for balancing the rights. No longer the courts, but the private entity, an internet company. Now, the Court of Justice, the Luxembourg Court, says the same thing. Intermediary or internet intermediaries should be given the right to police or to balance. There is the EU Copyright Directive, which in the explanatory materials says that internet intermediaries are best placed to balance infringing rights. And again, the Luxembourg Court in the Google judgment has said that, again, the same thing, internet intermediaries have central role. So what we can conclude, we can see that there is perhaps already a prevailing understanding that the task which should be entrusted to public entities, to the state, to balance conflicting rights, is given to private entities. No longer the state, private entities have to balance. And they do balance. They achieve this function. There is certain scholarly discourse about the same issue. And you can see in the scholarly discourse there is some methodological and some substantive questions. Methodologically, people write and say that, they criticize the court judgments. They say that the courts do not do enough. They don't provide a very clear roadmap. They fail to say exactly how the courts should balance. So from this methodological perspective, we see that there are lots of articles, even some monographies written, where scholars try to step into the shoes of courts and start to fill this vacuum. Just so many, I will just put them on this screen, so many different suggestions, notice and take down, notice and suspension, you wonder what they all are, but there are different methodological suggestions which the scholars do present. But we all understand that by making these suggestions, it is within the realm and paradigm of balancing. The scholars understand or assume that it is acceptable, it is good if internet intermediaries balance, and they try to help, in quote, those intermediaries. But there is also this substantive part of the scholarly discussion. And in substantive part, it is more critical. It is critical because scholars are writing and debating whether a fair balance really can be achieved through this. And they even refer to this kind of private censorship, that internet intermediary needs to balance its own cause. The conclusion we could make from here, from the literature, is that it would be acceptable if there were clear standards, good legal knowledge, and well-trained staff to do that. Sometimes in the literature, it is referred to this phenomenon of black box. More theoretically, perhaps we could say that it is the irrational balancing, an example of irrational balancing. Because when courts traditionally balance conflicting rights, they have adequate time. A judge can sit on a case 3, 4, 5, 10 years, if you will. somebody who is sitting in the office of Google or Twitter needs to decide with 1 minute how, if I take the information down or not. If I make a wrong decision, it stays there forever. It doesn't matter what happens after that. Judges have the possibility to obtain additional information. Quite difficult to do in the internet. The judges have also the legal knowledge of how to balance, and they have the mandate of neutrality, which the internet intermediaries don't have. I tried to visualize what is a black box, and when I told you I have some element of entertaining, now bear with me.
Arvate, et ongi kõik? Eksite? See pole veel pooltki läinud. Aga oled nii kiiresti, et ei jõua ninagi nuusata. Tuld! Kui see ei ole iime, mis siis üldse iime on? Soovite veel kirvi? Palun! See on veel kiirem kui tehnika imede ime! Jälle saadab, et on number 1. Pettus! Seal istub naine sees! Ei jõua lihtsalt, ei jõua kiiremini, ei jõua! Naine pole oli! Ma kaotasin. Jälle!
What you saw was a black box. We don't know what's inside, but at the end of the day, it is a person who is inside, and we don't know by what standards the person is guided by. Now, we have also a response by the intermediaries to this issue, whether rights can be balanced in internet. And we have a very strange and interesting situation developing. Namely, we see that the internet companies are very active to try to set the rules of the game. They are active in trying to set the standards by which they are guided by. And they do so in cooperation with the highest human rights authorities, if you will, in the globe. With the EU Commission, of course it's debatable if it's a human rights authority, but it has certain power, plus then the United Nations. For example, there is a code of conduct which was just recently, last year, adopted by powerful online companies like Facebook, Microsoft, Twitter, together with the EU Commission. And it is a document where these parties have agreed to certain rules of the game, like having dedicated teams reviewing requests, notification system, best practice sharing, provide regular training to the staff, on which I'm quite curious what does it mean, but we see that. We have the Internet Governance Forum, which is by the United Nations, which is financed by different stakeholders. The idea is again to develop standards. We have the so-called Manila Principles, where different scholars, universities and internet companies are participating, which have adopted different rules of the game, like rule number 4, which again says that the balancing needs to comply with the ideas of necessity and principiality. How many minutes? 5. Excellent. Now, but trying to now move to the end, what I think we see, there is a paradigm, not a paradise, but a paradigm of balancing in internet, which all the parties agreed to. You then have the Court of Justice, the Google, EU Commission, Twitter, Alexei, national courts, all of the different stakeholders. This is the paradigm of balancing. They are all operating in that paradigm. I think it's quite clear. There are no alternatives. What would be the other solution? No rules of the game. It would just be a chaotic movement if that paradigm collapsed. We also see now, in that situation, certain response from the legislature to try to retain the paradigm of balancing in EU. We have the EU data protection regulation, which in an unprecedented way sets possibility to fine very heavily internet companies who do not balance correctly, if you will. There are proposals to require the internet companies to take down all information. There is a statement of the Special Rapporteur of the United Nations to say that you should never trust the internet intermediaries with this. Now, do we see that there is perhaps a paradigm shift of balancing in internet at the horizon? We see that the courts reluctantly apply this doctrine because there is no choice, no real alternative for them. We see that the scholars are somewhat critical of the possibility to apply this balancing in horizontal situation. Legislature is preparing norms which I would call are stillborn because it's not realistic that they will work. Plus there is an economic burden on the internet intermediaries. Maybe the paradigm shift is already happening. The fake news, cyber attacks, national security argument, perhaps these are all saying that the paradigm of balancing does not hold. I do have, on the other hand, certain reflection on what might be, or perhaps is already suggested by some colleagues as an outcome. Namely, the concept of vulnerability. We use traditionally the concept of vulnerability towards minority groups, towards people or groups which need more empowerment. But the way how I understand the current discussions about vulnerability is it cannot be excluded that the entire population, everybody who is using internet, can be viewed as having the element of vulnerability, which I could call then the internet vulnerability. What would lead to what? It would lead that if you have this classical horizontal relationship, you add the vulnerability, then the starting point for all balancing is already for the benefit of privacy. And then you need to start adding weight to the other side. Now I'm coming back to my initial question. If we can say that there is such a thing as the right to internet, and what does this short discussion or analysis of the balancing tell us? If we are to apply Alexei's doctrine of human rights as the claim to correctness, then we need to conclude that in internet it's highly problematic to achieve correctness, which would mean then that if internet cannot achieve correctness, it cannot be regarded as a human right. But if you lift internet to the level of a human right, I think it might already, because of the balancing problems, have an imbalance built into it. for the favor of the freedom of expression. Whether it's good or bad, I'm not taking a stand. Thank you.